Hello, and thank you for joining us for our webinar today on the Data Use and Access Act 2025 Implementation, Obligations and Exploitation. My name is Nicola Kane. I am the CEO and Principal Consultant at Handley Gill Limited. We are an award-winning legal and regulatory compliance consultancy with specialisms in data protection, responsible AI governance, online safety, human rights and responsible business, and related ESG and GRC. In terms of the approach for today, we're going to talk just a little bit about what the Data Use and Access Act is, how it's been implemented, and we're going to take it step by step, taking us through essentially the order in which provisions were commenced under the Act, and ultimately coming to those provisions which are still outstanding. We'll discuss as we go through what that means for you, but we'll also highlight at the end some other resources. And we'll also have some dedicated time at the end for Q&A. But if you have any questions as we're going along, please do I think hopefully you should have access to a Q&A chat box. So you should be able to type in your question anytime, and you should also, I think, hopefully be able to raise your hand and ask a question, and we're really happy for you to intervene at any point to ask any questions you may have. There is quite a lot to cover today. We have got quite a long session, so hopefully you're sitting comfortably, you're well caffeinated, lock in. And as I say, if you do have any questions or anything's not clear, please do pause and give us a shout, and we'll take it from there. So, the Data Use and Access Act 2025. It's important to emphasise that the Act amends the UK's data protection legislation. It adds some new provisions and requirements. It takes some others away. It's very much an evolution rather than a revolution in terms of the UK's data protection landscape. But there are definitely some opportunities there to take advantage of for you and your organisation, to enable you to exploit personal data that you already have, potentially to gather more personal data, to use it in different ways. So there are provisions that you should definitely be aware of from that perspective, but there are also some new obligations that you're going to have to consider and prepare for. So royal assent was granted on the 19th of June 2025. The Act's actually in 8 parts. It doesn't just cover kind of traditional data protection. Part 1 covers access to customer and business data. Part 2 covers digital verification services. Part 3, the National Underground Asset Register. Part 4, provisions around registers of births and deaths. Part 5, data protection and privacy. Part 6, the Information Commission. Part 7, other provision about use of or access to data. And Part 8, the final provisions. And for our purposes today, and for the purposes of data protection practitioners, the focus is going to be on parts 5 and 6 of the Act and the amendments that they make to the UK GDPR, to the Data Protection Act 1998. Yes, we're still talking about that one, largely in the context of PECR and PECR enforcement. The Data Protection Act 2018 and the Privacy and Electronic Communications EC Directive Regulations 2003, better known to many of us as PECR. So, implementation. On your screen, hopefully you can see the timeline of how the Act has been implemented. So first of all, we had royal assent on the 19th of June. That brought certain provisions into force with immediate effect. It also, all provisions that conferred a power on the Secretary of State to make regulations or necessary for enabling the exercise of such power also came into force immediately. We then, the Data Use and Access Act also included provision to make certain provisions come into force with effect from the 20th of August 2025, and that was supplemented by the Data Use and Access Act 2025 Commencement No. 1 Regulations 2025, which brought some more provisions in with effect from that date. The next tranche came into force by way of the Data Use and Access Act 2025 Commencement No. 3 and Transitional and Saving Provisions Regulations 2025. They came into force with effect from the 5th of September, and we have jumped, you'll note, a set of commencement regulations there because they're not relevant to parts 5 and 6. The next tranche came in on the 17th of November. We just had another couple of provisions, these and the September provisions, all related to law enforcement provisions and changes under Part 3 of the 2018 Act. So again, that was the commencement number 3 provisions. We then had the bulk of the changes. It had been initially been indicated that the government anticipated these come into force around Christmas. Christmas came and went. We didn't see anything. And then the on the 5th of February, the provisions came into force with the relevant regulations having been made a week prior and only published on legislation.gov.uk 2 days prior. So very little notice of these provisions coming in, but these bring into force the bulk of parts 5 and 6 of the Act. And that was done by way of the Data Use and Access Act Commencement number 6 and Traditional and Saving Provisions regulations. And those same regulations have also indicated that the final substantive provisions that will immediately impact controllers will come into force on the 19th of June 2026, and those relate to complaints. So that's kind of the timeline we're dealing with, and we're going to take the provisions in the order that they were brought into force. So at royal assent, Section 1422B of the Data Use and Access Act brought into force Section 78 of the same Act, and that relates to the requirement to conduct searches in response to data subjects' requests with immediate effect. The ICO has now published guidance on those provisions. They came into force in June. The ICO's guidance on the right of access was updated on the 8th of December 2025. What do they say? Well, you may well be aware that there was a chain of jurisprudence under previous elements of data protection legislation, including under the 1998 Act, the 2018 Act, insofar as it was the GDPR and the 2018 Act. Obviously, now we're operating under the UK GDPR, the 2018 Act largely, and now the Data Use and Access Act 2025. But there was a string of jurisprudence that essentially said if you're dealing with subject access requests, what you have to do is conduct reasonable and proportionate searches. The government took the opportunity of the Act to codify that and implement the provision, which is now Article 15(1)(a) of the UK GDPR, and provides that the data subject is only entitled, in the context of a right of access request, a subject access request, is only entitled to such confirmation, personal data and other information as the controller is able to provide based on a reasonable and proportionate search for the personal data and other information described in that paragraph. So that's the information you have to provide around any third parties, for example, to whom you may have disclosed data, sources of data, those kinds of things. The ICO's guidance says you must make a reasonable and proportionate search to respond to a SAR. This means you must make reasonable efforts to find and retrieve requested information. You're not required to conduct searches that would be unreasonable or disproportionate. And in deciding what unreasonable or disproportionate is, you should consider the circumstances of the request, the volume of information you may need to search in order to respond, any difficulties involved in finding the information, and the fundamental nature of the right of access. But you must be able to show why a search is unreasonable or disproportionate. So in practice, what does that mean for controllers? Well, you should review and, if necessary, revise your internal guidance on data subject rights requests, when further information may or should be sought, and the circumstances in which an extension may be deployed. It's important to note that this provision in relation to the scope of searches is backdated to January 2024. So you might need to think about whether the provision potentially applies to any existing complaints or disputes relating to your compliance with the right of access. In practice, particularly when you're dealing with requests that are likely to pertain to a high volume of personal data, you may want to consider conducting kind of sample searches to identify how much data appears to have been identified. You may well wish to consider taking steps such as thinking about the search terms, like having a template of the search terms you might use when conducting a request. like standard ones. So, for example, if a request is in the context of an employment dispute, what kinds of information would you be looking for? That's likely to include things like performance reviews. The people you're likely to want to ask for information from are likely to include the manager of the person, for example. Those kinds of things, having almost a playbook for your handling, which you can then have as a standard that in the event when it comes to a complaint or a dispute, you'll be able to demonstrate to the regulator, the ICO, what your approach was and why it's reasonable. We have done some work on this in terms of what it means in practice. And when we get to the end of the session, we'll give you a QR code and there's a link on our website, and we'll send it out as well via email to everyone who's registered to a list of our resources that are relevant to this, and subject rights requests are one of those. So if you want to deep dive into this a little bit more detail, you'll be able to do that. Next, so provisions that were indicated either at royal assent or when in the Data Use and Access Act Commencement No. 1 regs as coming into force. So these are provisions that came into force with effect from the 20th of August 2025. Bulking them together, there were law enforcement provisions. So Section 69 relating to consent to law enforcement processing, Section 72 relating to processing and reliance on relevant international law, Section 75, fees and reasons for responses to data subjects' requests about law enforcement processing, and Section 82, logging of law enforcement processing, and Section 84, codes of conduct in the context of law enforcement processing, all came into force with effect from the 20th of August. Section 74 on the processing of special categories of personal data came into force. Section 76 and 104 on provisions relating to subject access requests came into force, and one element of the changes relating to processing for what's now called the so-called RAS purposes, which is scientific and historical research, archiving purposes in the public interest, and statistical purposes, RAS purposes. One provision of the changes relating to that came into force in August, but others were much more recent. So let's look into those. You've also got changes relating to the nature, role, and oversight of the ICO coming into force in August. Section 91 relating to the duties of the Commissioner to carry out their functions. Section 95, analysis of their performance. Section 102, an annual report requirement to produce an annual report on regulatory action. The status and the kind of existence of the establishment of the new Information Commission, Section 117 and Schedule 14, which relates to that. Certain provisions relating to codes of practice also came into force in August, so 92 and 93, and provisions relating to the Information Commissioner's powers, 96 and 97, which deal with notices and the power to require documents, although other provisions in the Data Use and Access Act relating to the Information Commissioner's enforcement powers have only come into force much more recently. And then you've got kind of a section of kind of more miscellaneous provisions. So Section 106, protection of prohibitions, restrictions and data subjects' rights. Section 107 on regulations under the GDPR. Section 108, further minor provision about data protection. And then several provisions relating to PECR. Section 109, which basically says we're going to refer in the Act to the PEC regulations. By that we mean PECR. Section 110 on the interpretation of the PEC regulations, Section 111 on the duty to notify in the event of a breach, and Section 113 on emergency alerts. But again, the bulk of changes to PECR have come into force much more recently than August. So let's deep dive into each of those sections. On law enforcement processing, as we said, Section 69, 72, 75, 82 and 84 came into force on the 20th of August. What do they do? Well, Section 69 of the Act aligned the definition of consent under Part 3 of the Data Protection Act 2018, which is if you're processing personal data, if you're a competent authority processing personal data for law enforcement purposes, you're not governed by the UK GDPR, you're governed by Part 3 of the Data Protection Act. And this aligns the definition of consent under Part 3 with that under the UK GDPR, essentially. Of course, there aren't a huge number of circumstances if you're where, as a competent authority, you will be processing personal data in reliance on consent, as opposed to your lawful basis for processing would be your powers and obligations to investigate, prosecute, protect against crime, etc. But there may be circumstances where you would. And this is just the relevant provision. Section 33, this is all changed here. This is all new. Section 33 1A, consent, definition, and then what the conditions for consent are at section 40A. So if you're a law enforcement entity, you'll want to review your records of processing activity, your ROPAs, your privacy notices, your DPIAs, etc., to identify your circumstances in which consent is being relied upon as the lawful basis for processing, make an assessment to ensure that your standard of consent meets the new heightened requirement now it's in force, and take any necessary measures to ensure that consent is in fact compliant. Section 72 of the Data Use and Access Act provides a lawful basis for the processing of personal data in the context of its provision to law enforcement. This is something that's relevant both to competent authorities, police forces who may be asking for the provision of such information from third parties, and to third parties who may be in receipt of requests from policing and law enforcement to provide copies of personal data held by them for their law enforcement purposes. And essentially, what is changing here is that down in Article 6 of the UK GDPR, in the text after subsection 3, you have the change here, and it reflects the basis for the processing referred to in Part E of paragraph 1. So if processing is necessary for the performance of the task of the controller, carried out in the public interest, or a task carried out in the exercise of official authority, that is not now restricted to tasks laid down by domestic law. It is extended to relevant international law, and that relevant international law, for now at least, is essentially what's commonly described as the Cloud Act. It's the agreement between the government of the UK and the government of the US on access to electronic data for the purpose of countering serious crime. So when police and law enforcement bodies, competent authorities are requesting information, particularly from people like communication service providers who are covered by the Cloud Act in connection with serious crime, they can now identify this lawful basis, which they can rely on in order to obtain the personal data lawfully to law enforcement. And that, coupled with some other changes that have come into force, provide those third parties who, if they're willing to give information voluntarily to policing in the absence of a court order, provides them with the lawful basis in order to do that. The next change, Section 75, granted the Secretary of State power to make regulations which would require competent authorities to publish details of the fees they charge in the event that they decide, rather than rejecting a request which is manifestly unfounded or excessive, they decide instead they're happy to deal with it, but they'll charge a fee for it. The Secretary of State can require them to publish details of what those fees will be. No such regulations have yet been made and shared. Section 75 also brings in a requirement for controllers to notify data subjects where a request is determined to be manifestly excessive or unfounded and is not going to be acted upon under Part 3. So as you can see here, this is done by way of amendments to Section 53 of the 2018 Act by adding in a new subsection 4A, and subsections 6 and 7, requiring that if you're not going to comply with the request because it's manifestly unfounded or excessive, you must tell the data subject that without undue delay in any event before the time period expires for complying with the request, tell them the reasons for not doing so and of their right to lodge a complaint. So if you are a competent authority or acting for one, you will want to monitor the making of regulations which would require the publication of fees and amend your templates and processes to ensure that data subjects are informed and provided with the necessary information when a request is determined to be manifestly excessive or unfounded and will not be acted upon. Section 82 of the Act removed the obligation to record the justification for consultation and disclosure of part of logging requirements under Part 3 of the Act. So you'll see here Section 62 of the Data Protection Act 2018, which deals with logging at Parts 3 and subsections 2 and 3, justification for, has gone. As a consequence, you'll want to consider whether you wish to continue to collate and retain that justification as part of your logs now this is in force. You want to consider removing that element of the obligation from your data processing agreement templates and when agreements are due to be renewed. If you're working with third-party suppliers, that's often quite problematic. Often their systems and processes don't make provision for logs of justification for why you're looking or doing at something or doing something. So you may have had to adopt manual processes, or they have had to have done additional coding to essentially build that functionality into their products for you. That's potentially something that could drop away. You might want to consider disabling any such tools and revising reminders or templates that call for the recording of that information. Section 84 introduced an obligation on the Information Commissioner, or the Information Commissioners it's going to be, to encourage the preparation of codes of conduct in connection with processing for law enforcement purposes, with such codes constituting a means of demonstrating compliance for both controllers and processors. That already exists, obviously, under the UK GDPR for entities governed under that regime, but wasn't enforced for competent authorities under Part 3. And that's done by way of amending Section 56, the general obligations of the controller. And at subsection 4 there, you'll see adherence to a code of conduct approved under Section 71A may be used by a controller as a means of demonstrating compliance with the requirements of this part. So it cements the use of codes of conduct for compliance and for demonstrating compliance, and Section 71A of the Act now requires the Commissioner to encourage such codes of conduct to be produced in connection with processing under Part 3. So for your organisation, if you're a competent authority or advising one, you'll want to consider what opportunities there may be to design codes of conduct to introduce standardisation and compliance assurance, whether that be across specific types of organisation, so across police forces or across ROCUs, or specific processing activities across a variety of organisations. So that could be something like in connection with data sharing, in connection with obtaining personal data. It could be in connection with specific things like, for example, facial recognition, live facial recognition. There could be a code of conduct for that. And if that's something you're considering, you may want to consider establishing a working group to design such a code and submit it for approval. So that was the law enforcement lump of stuff that came in on the 20th of August. The next change was in relation to special category personal data. And that was Section 74 on processing of special categories of personal data. So Section 74 of the Data Use and Access Act 2025. And what that did was to introduce a new power for the Secretary of State to expand the scope of personal data subject to the restrictions at Article 9 of the UK GDPR. So what we consider special category personal data under the Data Protection Act 2018 and the UK GDPR. In the pre-UK GDPR and Data Protection Act world, it's what we used to call as sensitive personal data, but essentially personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs or trade union membership, and the processing of genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a natural person's sex life or sexual orientation. So potentially there could be new things added in. You could see a scenario, for example, if the government decided they wanted to try and encourage organisations to take better care of personal data that is sensitive for other reasons, for example, financial data. This could potentially be a way of doing that. There could be other reasons why the government might want to do it. No such regulations have been made to date, but, and that's just at Article 11A, you can see the provision that introduces the power to make such regulations. But while no regulations have been made to date, it is something you'll want to keep an eye out for, the making of such regulations, because obviously then if there are new categories of essentially special category personal data, you'll need to make sure you're complying with all the requirements relating to that. that they have the appropriate protections. It will be relevant to automated processing of such data. There are several other provisions that will be relevant that you'll need to consider. You'll need additional lawful bases, that kind of thing. Next chunk of stuff was data subject rights requests. So Section 76 and 104 of the Data Use and Access Act 2025 came into force in August. Section 76 amended how the time for compliance should be calculated when dealing with data subject rights requests. It expanded the grounds for delaying a response to a request, clarified the grounds upon which an extension of time for responding to a request may be claimed. And Section 104 provided a mechanism to allow for material subject to a request to be disclosed to the court but withheld from the claimant in any ensuing legal proceedings. So dealing with time periods for complying, there have been amendments made to Article 12 of the UK GDPR and a new provision inserted. So Article 12.3 of the UK GDPR, instead of saying that you had to comply without undue delay and in any event within a month, it now says you have to comply without undue delay and in any event before the end of the applicable time period, which is introduced by Article 12A. Similar provisions then are made at Article 12.4. At Article 12.6 of the UK GDPR, it now makes clear that where you have reasonable doubts concerning the identity of a person making the request, you can request provision of additional information necessary to confirm their identity and delay dealing with the request until that identity is confirmed. That's now made clear there. And then the way you calculate the applicable time period, it's at Article 12A, it's the period of 1 month beginning with the relevant time. The relevant time is when you receive the request or when you receive the information or when the relevant fee, if you're entitled to charge a fee, is paid broadly. You've still got the potential to extend the applicable time period by up to 2 further months. But what is made clear is that it's not just having regard to the complexity or number of requests, which is what we had when we were dealing with the GDPR, the UK GDPR pre-Data Use and Access Act, and the DPA 2018. So what's clear now is what's relevant is the complexity of requests made by the individual data subject, not the complexity of the requests you're dealing with generally. And the number of requests made by the data subject, not the number of requests you're dealing with generally. There has been a tendency on the part of controllers to say, essentially, we're very, very busy. We've got lots of requests. They're all very complex. We can't respond to you in time. We're taking an extra 2 months to comply with your request. This is indicating that is not going to be permissible. Whether it will make much difference in practice because of the changes to complaints, we'll see. We'll get to that later. But technically, there is a change there that you need to be aware of. And Section 180A, the new Section 180A Data Protection Act 2018 that's been introduced, deals with the procedure of the court as to who is entitled if there is a dispute over a subject access request, makes clear that the claimant in that case wouldn't be entitled to see the material unless ultimately the court rules in their favour. This has, until now, essentially been dealt with through just procedural rules and directions of the judge in the relevant proceedings, but that is now a statutory provision. What does it mean for you? You'll want to review and, if necessary, revise your internal guidance on data subject rights requests when further information may or should be sought and the circumstances in which an extension may be deployed. Now this provision is in force. Ensure you have sufficient capacity to handle data subjects' rights requests within the permitted timescales if you have been relying on that extra 2 months and that period is now coming down. Bear in mind, data subjects, there are changes coming into complaints which may make it less likely that the ICO acts on a complaint, but data subjects nevertheless do have the right to go to court and pursue their rights through that mechanism instead. That may well become more likely in light of the changes to complaints and the ICO's intentions in relation to enforcement. So bear in mind that may be something your organisation needs to consider your resourcing for. And you'll also bear in mind that if you're managing disclosure in the context of a data subject access request dispute, to ensure that you withhold the requested material, you're not going to be obliged to disclose that. The next change relates to processing for the so-called RAS purposes, scientific and historical research, archiving in the public interest and statistical purposes. And this changed the requirements, only one of the changes relating to the RAS purposes, but Section 77 of the Data Use and Access Act makes changes to the information required to be provided to data subjects and essentially restricts that information. You don't have to provide as much information necessarily to data subjects if you're processing for the RAS purposes. This is done by amending Article 13 of the UK GDPR and adding in some new provisions, Article 13(5) to 7. So paragraph 3, so that is relates to further processing. So if you're processing personal data for the RAS purposes and you want to further process the personal data, so this is personal data was collected for purpose A and you now wish to use it for purpose B for the RAS purposes, you will not necessarily be required to provide the transparency information around your processing to the data subject prior to conducting that further processing. If you're going to be processing for and only for the RAS purposes, and you're meeting the safeguards relating to processing for the RAS purposes, and providing the information is impossible or would involve a disproportionate effort. And then the new Article 13(6) provides that when you're considering whether providing information would involve disproportionate effort, you should have regard to, this is a non-exhaustive list, the number of data subjects involved, the age of the personal data, and any appropriate safeguards applied to the processing. The consequence being, if you're intending to do processing for RAS purposes for a new purpose of a bulk data set that's it's kind of more aging, you're likely to be able to say it would be disproportionate to tell people we're going to use the personal data for the new purpose. If you're complying with safeguards, then you will not have to notify and you'll be able to go and take that data and use it for your new purpose. If you are relying on that provision, there is kind of a further emphasis. You have to take appropriate measures to protect data subjects' rights, freedoms, and legitimate interests, including by making the information available publicly. So you might decide it's disproportionate to tell people, but if we're going to have a website, maybe if you're at a university, you might put something on your university website. If you're doing academic research or scientific research in an academic context, if you're, working for a company, then you'll want to amend your privacy notice accordingly and make that information available. Similar provisions are then provided at Article 14 of UK GDPR. So whereas Article 13 relates to the transparency information you're required to provide to data subjects where you obtain their personal data directly, Article 14 deals with where you've obtained their data from a third party and has now made similar changes. So what does it mean if you're processing for the RAS purposes? Ensure you've got your relevant safeguards in place. And again, we'll come back to that later because it's slightly odd mix of how the government chose to commence the provisions. Consider whether you need to revise your privacy notices, ROPAs and DPIAs in relation to new processing activities, and make sure that you're reflecting any new processing activities in your templates and records. Make sure you're identifying and recording any RAS purposes processing that you're doing in your templates and records. So make sure you've got kind of a specific column to say this is processing for RAS purposes. For example, might be a way to do it, or, color coding, whatever you use internally, to make sure that you're identifying that, because there are a range of measures that will apply differently to processing for RAS purposes or won't apply at all. And it's important then that you're able to take advantage of those and identify them easily. Next change is related to codes of practice. So from August, sections 92 and 93 came into force. These restate the obligations on the Information Commissioner or the Information Commission as it will be, relating to the preparation and publication of codes of practice, but have introduced a new mechanism for the preparation and approval of the codes, as well as an obligation to prepare and publish an impact assessment. Now, remember, I always get this wrong. Um, Codes of practice are the statutory codes. So the ICO is required by the Data Protection Act 2018 to prepare certain codes of practice, for example, relating to processing of personal data in the context of journalism, the age appropriate design code, also called the Children's Code. Codes of conduct are the things that industry prepare. This relates to codes of practice. So, Section 128 of the Data Protection Act 2018, which related to other codes of practice, there were a list of codes of practice it had to do, direct marketing, data sharing, age appropriate design code or children's code, journalism, I think were the only ones. That is, and then there was provision for them to make other codes of practice. Section 128 has now been removed. It's replaced by Section 124A, makes provision saying it must prepare appropriate codes of practice, giving guidance as to good practice. Where such codes are in force, amendments of the code or replacement code can be prepared. Before preparing a code or amendments, the Commissioner must consult both the Secretary of State and such of the following as the Commissioner considers appropriate, being trade associations, data subjects, and persons who appear to the Commissioner to represent the interests of data subjects. In addition, where a code is prepared under sections 121, 122, 123, 124, 124A, so those are a code in relation to direct marketing, data sharing, processing of personal data for the purposes of journalism, art, or literature, the age appropriate design code or the children's code, or these other codes, as well as consulting the trade associations, data subjects, and people who represent them insofar as it considers appropriate. The Commissioner must now establish a panel of individuals to consider the code, comprising individuals the Commissioner considers have expertise in the relevant subject matter, and individuals likely to be affected by the code or to represent persons likely to be affected by the code. The code must be published in draft. There must be a statement that, and then the panel must be established, and the Commissioner must publish a statement that says a panel's been established, identifying who's on the panel, the process by which they were selected, and the reasons for their selection. So this is going to be quite different. It's very new arrangement. It'll be very interesting to see in practice when it comes to revision of the codes or establishment of new codes, how this actually works and what the Information Commissioner does. Essentially, what happens is the panel then has to produce a report on a code. The Commissioner then has to consider that and make any alterations to the code that is considered as appropriate, must then publish the code in draft, publish the panel's report or a summary of it, and where they don't accept any of the recommendations of the panel, explain what they've not accepted and why it's not been accepted. Panel members have to be paid. They get remuneration and expenses, so it could be quite interesting and potentially, well, I doubt lucrative, but still an opportunity to be paid for your time rather than doing things for free. And then as well, the new section 124C of the Data Protection Act 2018 requires that in relation to any code, an assessment of who would be likely to be affected by the code and the effect the code is likely to have on them, relating to the existing statutory code as well as any new ones, must be produced. So you have to do, the Commissioner will have to do impact assessments. In practice, therefore, that means that you need to monitor for the making of regulations mandating new statutory codes over and above the existing codes. And you also want to consider whether and how you're going to participate in and engage with code panels and impact assessments. There's clearly opportunities there for kind of lobby groups and others to engage heavily in the context of those consultations, to get involved in the panel. That could mean very different approaches and concerns being raised. So if you think about some of the, for example, let's say it's the Children's Code. Members of the House of Lords who have expertise in this area have worked with civil society organisations to work on seeking to bring into force additional provisions and various bits of legislation that have been going through, whether that's the Online Safety Act, the Data Use and Access Act, the Children's Wellbeing in Schools Bill going through currently. Those individuals could potentially apply, assuming it's going to be a process of application, to be on a panel. And if they were involved, they could well, if not achieve amendments, certainly, and certainly achieve a reputational impact and put reputational pressure on the Information Commissioner to accept certain changes. So that'll be really interesting. And so whether you're on whichever side of the debate you are on when it comes to the codes, you'll want to ensure that as an industry, as an organisation, you are engaging effectively with those opportunities, because failing to do so could result in people who want maybe more significant changes or less significant changes being on panels, and being able to apply political pressure essentially on the regulator to make changes one way or another. And from the August changes, the other section related to the Commissioner's enforcement powers, in particular sections 96, which related to notices from the Commissioner, and section 97 relating to the power of the Commissioner to require documents. Section 96 effectively modernised the Information Commissioner's ability to serve notices by permitting notices to be served by email. Section 97 granted the Information Commissioner power to require the provision of documents as well as information by amending Section 142 of the Data Protection Act 2018. So notices from the Commissioner, Section 141 of the Data Protection Act 2018 has been deleted, replaced by Section 141A of the Act. Makes clear that notices can be given by sending it by email to the person's email address. Various other provisions relating to that, like what is a person's email address? It can be what's published by that person, or an email address that the Commissioner reasonably believes will come to the attention of that person. Quite vague. So as such, you're going to need to consider that really carefully, and we'll come to that in a second. So yeah, what does it mean for you? You're going to want to update your training to ensure that notices from the Information Commissioner that might now be received by email are recognised and directed appropriately by your staff. You might also want to consider whether you want to update your registered email address on the register of fee payers, if that applies to you, to make sure that if that's the address that they've got, that's the most appropriate one. If they're going to send a notice, a statutory notice saying you're required to provide us with information with a certain period of time, for example, that's going to go to the best place for dealing with that. That might be your data protection team. You might feel it's your litigation team or someone else, but you might want to just think about that. And there are also some changes to the nature, role and oversight of the ICO. So Section 91 relating to the duties of the Commissioner in carrying out his functions, Section 95 analysis of performance, 102 annual report on regulatory action, Section 117 relating to the new or forthcoming Information Commission. Section 91 introduced a statutory duty on the Information Commissioner to prepare and publish a strategy for the fulfilment of its functions, with the first to be produced within 18 months of commencement of the Act. So where are we now? We're in March. So we're already coming up for a year of the Act. So it's not going to be that much longer, roughly by the end of this year, to consult with other regulators as to the manner in which it fulfills its functions and to report to Parliament on the fulfilment of its functions. Section 95 of the Act required the Information Commissioner to conduct and publish an analysis of its performance. Section 102 required the Information Commissioner to publish a report on its enforcement action. Section 117 established the body corporate of the Information Commission, and then Schedule 14 makes various transitional provision for the role of the Information Commissioner and other appointments as the Information Commissioner and his office transitions into the new Information Commission. So let's have a look what that looks like. In relation to duties carrying out functions, which is the change introduced by Section 91, there is a new Section 120A of the Data Protection Act. So the principal objective of the Commissioner in carrying out his functions is to secure an appropriate level of protection for personal data, having regard to the interests of data subjects, controllers and others in matters of general public interest, and to promote public trust and confidence in the processing of personal data. In fulfilling its functions, the Commissioner must have regard to such of the following as appear to be relevant in the circumstances. Some of this is kind of new. Some of it was already reflected in the Digital Economy Act. But the provisions are the desirability of promoting innovation, the desirability of promoting competition, the importance of the prevention, investigation, detection and prosecution of criminal offences, the need to safeguard public security and national security, the fact that children merit special protection with regard to their personal data because they may be less aware of the risks and consequences associated with processing of personal data and of their rights in relation to such processing. That was something that was forced through into the Act by the House of Lords. There is a concomitant provision, which we'll come to a bit later. But that's important. Obviously, those are the things the Commissioners should be having regard to. There was then a requirement introduced at Section 120C to prepare a strategy for carrying out their functions, which must be reviewed and revised from time to time and published. In preparing that, generally how to comply with their functions, the Commissioner must, in accordance with the new Section 120D, consult with other appropriate regulators, essentially, in the manner in which they exercise their functions and how it may affect economic growth, innovation and competition. And then in connection, a new section, a change to Section 139 of the Data Protection Act 2018 is introduced at a new subsection 1A. In connection with the Commissioner's functions under the data protection legislation, the annual report must contain a review of what they've done within the relevant period to comply with various duties. And the new Section 139A, Data Protection Act 2018, requires the Commissioner to prepare and publish an analysis of performance using KPIs. There must be an annual report in accordance with Section 161A of the Act on regulatory action, including quite specific information, the number of investigations begun, continued or completed, the different types of act and omission that were the subject matter of the investigations, the enforcement powers that were exercised, how long the investigations lasted, what were the outcomes of the investigation. There's going to be some really interesting and helpful information for practitioners when thinking about what is happening, what is the regulator actually doing, what are the risks, what are our risk areas, what is attracting the regulator's attention. So as this information, first of all, you've got the Information Commissioner's focus, areas of focus and particular things they're looking at, including in particular children's rights. So you might want to think about your processing activities and reassess your risk appetite in light of the revised focus. And you might want to revisit existing projects, previously rejected projects, to consider whether the assessment of risk should be revised. You're going to want to monitor the publications that are going to be coming out from the Commissioner around regulatory and enforcement action to ascertain, what's the nature, frequency, target of regulatory and enforcement action. Are there any changes to the approach of the Commissioner? Does the establishment of the Information Commission, is that having any difference? That all of that information should then be informing your risk assessments when you're thinking about what you're doing. One thing to be aware of is that there has been a lot of criticism, as you probably know, of the Information Commission and its approach to enforcement action and regulation. There is the potential, clearly, for disclosures of how many complaints have been investigated, how many investigations have been opened, how many have been concluded, what have you done about them. That could lead to further criticism. It could lead to further political or public pressure for the commissioner, or the new commission as it will become, to take further action. So you'll want to just be monitoring what impact, as these provisions are coming out, what impact is having. Are there any shifts? The next lot of changes that came in August related to PECR. Section 109 essentially just said we're going to call in this act the PECR the PEC regulations. But substantive provisions were at Section 110 relating to the interpretation of PECR, Section 111 duty to notify the Commission of a personal data breach, and the time periods for that, and Section 113 emergency alerts. So for the first time, Section 110 of the Data Use and Access Act has introduced a definition of direct marketing into the Privacy and Electronic Communications EC Directive Regulations 2003. Direct marketing is the communication by whatever means of advertising or marketing material which is directed to particular individuals. Section 111 amends Regulation 5A of PECR so as to impose a 72-hour backstop deadline for providers of public electronic communication services to report personal data breaches while retaining the obligation to report without undue delay. So essentially, the importing the UK GDPR time limit for reporting data breaches has been imported into PECR for public electronic communication services providers. Section 113 clarifies how time should be calculated in relation to the period for which restrictions on processing subscribers' and users' personal data can be set aside when public electronic communication services providers are providing an emergency alert service under Regulation 16A of PECR, just how you calculate your 7-day time period for that. And then there were several miscellaneous provisions, 106, 107, 108. Section 106 made provision that the imposition of a power or the conference of a duty in the Act doesn't override the data, or in other legislation doesn't override the data protection legislation, but it should be taken into account when considering the application of data protection rights and obligations. Section 107 made provision about the requirements on the Secretary of State when making regulations under the Data Use and Access Act, so how he has to go about making regulations, what are the requirements depending on whether it's going to be under the affirmative or the negative resolution procedure. Section 108 refers to Schedule 11, which makes various kind of minor amendments to data protection legislation, but also incorporates the definition of direct marketing that we've just discussed, having been introduced at PECR here, is also introduced to Article 4 of the UK GDPR. So that was kind of the first substantive chunk of provisions that were brought into force. The next chunk of provisions that came into force came in were commenced by the Data Use and Access Act 2025, Commencement No. 3, and Transitional and Saving Provisions Regulations 2025. These were law enforcement provision focused. The ones that came into force on the 5th of September, Section 79 relates to data subjects' right to information and introduced a legal professional privilege exemption. You might have thought it should already be there. Clearly, the government agreed. And an exemption at Section 88 for national security. So, as I say, Section 79 introduces an exemption in respect of material protected by legal professional privilege for the purposes of Part 3 of the 2018 Act. That's done by introducing a new Section 45A. And if you're affected by that, you'll want to update your internal guidance processes, templates, training to highlight the scope of your obligations and the exemptions that can be relied on, including this new exemption. In practice, it was effectively being relied on, and people were saying it's confidential, it's privileged, we're not disclosing it, it wasn't disclosed. That's now the issue there. The lacuna has been resolved. And Section 88 introduced a national security exemption applicable to compliance with certain data protection principles, data subject rights, breach notification, etc., under Part 3 of the Data Protection Act. And that was a precursor to certain other changes that were yet to come into force relating to joint processing between competent authorities and the intelligence services. That was done by introducing a new Section 78A of the Data Protection Act 2018. So again, you'll want to update your internal guidance processes and templates to ensure you're reflecting that there is an entitlement to rely on the national security exemption now it's in force. Those same commencement regulations also provided for further provisions to come into force but at a later date on the 17th of November 2025. And again, they were law enforcement focused. And these are the ones I referred to around joint processing between competent authorities and the intelligence services, Section 89 of the Data Use and Access Act 2025 and Section 90. They effectively extend protections afforded to personal data processed by the intelligence services to personal data being processed jointly by competent authorities and the intelligence services in circumstances where this is subject to a designation by the Secretary of State. There are various provisions around the circumstances in which there can be joint processing, the criteria for a designation to be made, how a designation should be applied for and made, those kinds of things. But essentially, dealing with the problem that if where you had processing by the intelligence services and the police were going to work with the intelligence services, it made data sharing more risky between the two organisations because more data would be subject to disclosure, for example, by police than would be the case in relation to the intelligence services. So when I'm talking about extended protections afforded to personal data processed by the intelligence services, those are protections for the intelligence services and now where there's joint processing competent authorities rather than additional protections for data subjects. Those provisions are set out in new sections 82A, B, C, D and E of the Data Protection Act 2018. So if you're a competent authority, you'll want to consider the circumstances in which a joint application with the intelligence service may need to be made and when you're applying for a designation. Now those provisions are in force, and update your internal guidance, process templates and training to ensure your protections afforded to designated processing and data are applied and applied properly. You do not want to have designated data being erroneously disclosed. So the next and most important set of provisions comes about when the Data Use and Access Act 2025, Commencement No. 6 and Transitional and Saving Provisions Regulations 2025. These are this was the regulations that the set of commencement regulations that were issued at very short notice. We had expected something maybe before Christmas. They were made in March. They were published in early February. They came into force on the 5th of February. These are the regulations that are commencing the bulk of the changes introduced by the Data Use and Access Act 2025, Parts 5 and 6. The bulk of the changes to UK data protection legislation are coming into force here. And there's a swathe of them. So we've bulked them together. So there are provisions relating to the RAS purposes. So that's the scientific and historical research archiving in the public interest and statistical purposes. So these are changes relating to Section 67, the meaning of research and statistical purposes. Section 68, consent to processing for the purposes of scientific research. Section 86, safeguards for processing for research purposes. Section 87, consequential provisions. Also changes to the lawfulness of processing, so it's Section 70 and Schedule 4 of the Data Use and Access Act 2025, implementing a new lawful basis for processing that of recognised legitimate interests. Section 71 and Schedule 5, introducing a concept of processing deemed to be compatible with the original purpose, so amending the purpose limitation principle. Section 72.3 and 7 relating to processing and reliance on relevant international law. So we talked earlier about the change where public authorities could process personal data. Their lawful basis didn't just have to be in domestic law, it could also be under relevant international law, which is currently defined solely by reference to the Cloud Act. Some further changes there. Section 73 of the Act relates to elected representatives responding to requests. Section 80 and Schedule 6 make changes to automated decision-making restrictions. Section 81 introduces a new concept called children's higher protection matters, and this reflects the new requirement on the ICO in fulfilling its functions to have regard to the special status of children. This is the concomitant obligation on controllers. Section 83 relates to general processing and codes of conduct. That's the codes of conduct are what industry produce among themselves and have approved. Section 85 makes and Schedule 7, 8 and 9 make changes in relation to transfers of personal data overseas and to third country organisations. Section 94 makes provision in relation to manifestly unfounded or excessive requests to the Commissioner. Various provisions come into force relating to the Information Commissioner's enforcement powers. Section 98, the power to require a report. Section 99, assessment notices. Section 100, interview notices. Section 101, penalty notices. Consequential amendments are made to the EAT set regulations at Section 105. Don't worry if you don't know what I'm talking about, because I'll address it. The chunk of provisions, most of the provisions making amendments in relation to PECR have come into force, relating to the interpretation of the regulations, cookie requirements when you need cookies, emergency alerts, use of email for direct marketing by charities is a big one. Essentially, a charitable soft opt-in has come into force. Commissioner's enforcement powers under PECR will be really important for everyone because it massively changes your risk profile. Also has implications for things like insurance. PECR codes of conduct, Section 116 is made provision for, and then schedules relating to those changes. And then at Section 120, changes relating to the establishment of the Information Commission, the transfer of property between the Commissioner, the new Commission. And then Schedule 11, various kind of minor provision about data protection also came into force. And we're going to take them not in that order, but we're going to bulk those together and look at the changes that have come into force. Now, we'll start with the recognised legitimate interest lawful basis. One thing to say is that anecdotally, if you're looking at this and thinking, oh gosh, this all came into force over a month ago, panic. Largely, the changes that are coming into force are permissive rather than imposing new obligations. There are some, but they're not particularly substantive. And anecdotally, our experience is that most organisations have not pre-prepared in order to take advantage of the changes or to implement the changes. I think people were maybe expecting something before Christmas. It didn't come. There was no indication of when we would get the regulations or how long we'd have to comply. And as I say, anecdotally, our experience working with our clients and also working with attendees of our data protection practitioner discourse, DPPD sessions, is that most organisations have waited for the regulations to come into force and are now taking steps to understand the changes and what they mean for them and to consider what they need to do to comply with them. So don't panic. You're not particularly behind, but now's a good time to get on top of these changes and think about what they mean for you. Bit of spring cleaning. So, the new recognised legitimate interest lawful basis. Section 70 and Schedule 4 of the Data Use and Access Act 2025 have introduced a new lawful basis for processing personal data under Article 6 of the UK GDPR. That is the new lawful basis of what's called recognised legitimate interests. This has been done by incorporating new provisions into the UK GDPR. There is a new Article 61EA of the UK GDPR and an Annex 1 of the UK GDPR and some consequential amendments. The ICO has published draft guidance on the recognised legitimate interest lawful basis. That has not yet been finalised. I'm pretty sure that was one of the ones that was subject to consultation. I think we probably did a response to it. I can't remember, there have been so many at this point. There'll be information on our website and in the resources section about it. So, but there is draft guidance out there currently. So if you want to get at least a steer of where the ICO is kind of positioning itself on this, you can access that guidance. Broadly, the changes are, so here you've got Article 6 of the UK GDPR, and you can see the changes. There is a new Article 61EA, so processing shall be lawful only if and to the extent at least one of the following applies, and you've got processing is necessary for the purposes of a recognised legitimate interest. And then a new Article 6.5 for the purposes of paragraph 1EA, that is the recognised legitimate interest. Processing is necessary for the purposes of a recognised legitimate interest only if it meets a condition in Annex 1. There's then provision for the Secretary of State to amend Annex 1 in certain circumstances, make certain amendments. There's also, incidentally, a provision here around when we're thinking about what is processing of personal data for legitimate interests. So under Article 6.1f, you've got the new Article 6.11, which says for the purposes of paragraph 6.1f, examples of the types of processing that may be processing that is necessary for the purposes of legitimate interest include processing necessary for direct marketing, intergroup transmission of personal data, processing necessary for security of network and information systems. Those are not recognised legitimate interests. You will still need to do a legitimate interest assessment in connection with those, either on a standalone basis as part of a DPIA. But it's just giving people a steer and perhaps some certainty and confidence that those are legitimate, potentially legitimate interests. You've then got this new category of recognised legitimate interests for which you do not need to do a legitimate interest assessment. And these are disclosure for the purposes of processing it described in Article 6.1e. So that's where you've got competent authority, public authority, someone acting in the course of their public function saying, I want you to disclose information to me, that they make a request to your organisation. You can then rely on this new recognised legitimate interest lawful basis to say, well, we're going to disclose that information to you. We don't need to do a legitimate interest assessment, but bear in mind, it's not a complete answer. Use processing still has to be fair. It still has to be lawful. So if you are voluntarily disclosing personal data to a public body, in the absence of a court order, for example, or another statutory notice or something like that, if you're voluntarily doing it, this will provide you a lawful basis to do that, but your processing must still be fair and lawful. Other recognised legitimate interests are processing necessary for safeguarding national security, protecting public security, or for defence, where necessary for the purposes of responding to an emergency. And that would include things like a pandemic, like COVID. If you need to process personal data in that context, that would be covered by that. Processing necessary for detection, investigation, or prevention of crime or apprehension or prosecution of offenders. Processing necessary for safeguarding vulnerable individuals. So, as we say, the effect of these changes is to remove the need to conduct a legitimate interest assessment in respect of processing for purposes of any of those recognised legitimate interests. Reliance on that new lawful basis will require you to update your records of processing activities and privacy notices, as well as other compliance documentation such as DPIAs. And you'll want to monitor for new regulations being made, expanding the scope of the recognised legitimate interest lawful basis. Then some changes relating to performance of a task carried out in the public interest, revision of the wording of Article 6.1e of the UK GDPR. And we've talked about this already. It's task of a controller, task carried out in the public interest. The basis under Article 6.1.3 in the paragraph underneath that, the basis for the processing referred to must be laid down either in domestic law or relevant international law currently being defined by the Cloud Act. So if you're a public body, you'll want to review your ROPAs, your privacy notices, DPIAs, processing agreements, etc., to ensure that the other changes relate to whose task it is. So Article 6.1e, processing is necessary for the performance of a task of the controller carried out in the public interest or a task carried out in the exercise of official authority vested in the controller. The idea being that your processor's lawful basis can come from that of the controller. So if you'll want to make sure that where you're relying on 6.1e as your lawful basis for processing, the relevant public interest task or task in the exercise of the official authority is that of the relevant authority, not of another controller. Consider whether any processing activities fall within or could fall within the scope of the purposes of responding to a request, making or responding to a request made under the Cloud Act, and monitor for regulations expanding the scope of what constitutes relevant international law. Are there other things that you can do? Next chunk of things we're going to talk about is purpose limitation. So Section 71 of the Data Use and Access Act has amended the purpose limitation principle at Article 5.1b of the UK GDPR, making consequential amendments, retaining the factors to be taken into account when conducting a compatibility assessment to determine whether further processing is compatible with the original purpose of processing, and establishing several categories of further processing which will be deemed to be compatible with the original purpose for processing. The Information Commissioner's Office indicated that final revised guidance on purpose limitation would be published in winter 25-26, but we are currently still waiting for that. So what are the changes? Well, this is Article 5 of the UK GDPR. And Article 5.1b now reads that personal data shall be collected, whether from the data subject or otherwise, for specified, explicit and legitimate purposes, and not further processed by or on behalf of a controller in a manner that is incompatible with the purposes for which the controller collected the data, the purpose limitation principle. Slightly amended because they've taken out the references to the RAS purposes because they're now kind of moved to a distinct section. New Article 5.3, for the avoidance of doubt, processing is not lawful by virtue only of being compatible processing. And then you've then got a new Article 8A, which deals with further processing and purpose limitation. So it says that if you're going to process for a new purpose, you have to determine whether the processing is compatible. In making the determination, you must take into account any link between the original purpose and the new purpose, the context of collection, including the relationship between data subject and controller, nature of processing, including whether the processing is described, whether the processing relates to special category personal data or personal data relating to criminal convictions and offences, the possible consequences of the intended processing for data subjects, and the existence of appropriate safeguards such as encryption or pseudonymization. As you'll see, those provisions were previously included at Article 6.4 of the UK GDPR. They've now essentially been moved to Article 8A2. There's then this new provision, so processing of personal data for a new purpose is to be treated as processing in a manner compatible with the original purpose for certain circumstances. Those being, this is Article 8A3, where the data subject consents to the processing of personal data for the new purpose, and the new purpose is specified, explicit and legitimate. Processing is carried out in accordance with Article 84B for scientific or historical research, archiving in the public interest or statistical purposes. So RAS purposes, complying with safeguards. The processing is carried out for the purposes of ensuring that processing of personal data complies with Article 5.1, First Data Protection Principle, or demonstrating that it does so. The processing meets a condition in Annex 2, I'll come back to that in a second. The processing is necessary to safeguard an objective listed in Article 23(1)(c) to J, and is authorised by an enactment or rule of law, and those are broadly the things reflected at here in our Annex 2, national security as well, those kinds of things. So these new conditions, you've got some new conditions are in the body of Article 8A3, some are in a new Annex 2. So processing will be deemed to be compatible, and by deeming it to be compatible, you don't have to do a compatibility assessment, whether on a standalone basis or as part of a DPIA or a legitimate interest assessment. But your processing still has to be fair and lawful. But you won't have to do a compatibility assessment because processing is deemed to be compatible where it's necessary for disclosure to another person in response to a request where they're carrying out their task. So this is that public authority, policing, whoever make a request of you, you want to respond to that. That's going to be deemed to be compatible with the original purpose for processing. Disclosure for the archiving in the public interest, where it's necessary for the purpose of protecting public security, necessary for the purpose of responding to an emergency, necessary for detecting, investigating or preventing crime or apprehending or prosecuting offenders, necessary for the purpose of protecting the vital interests of a data subject or another individual, necessary for safeguarding a vulnerable individual. Obviously, you'll see there is consistency among some of the changes being introduced in relation to recognised legitimate interest, deemed compatible processing. Essentially, the same provisions are applying. So what does that mean for you? You'll want to revise your compatibility assessment templates to reflect the new requirements, your training, etc. Guidance. Consider revisiting any data reuse projects that have previously been rejected to ascertain whether they could now be deemed to be compatible or if the assessment of risk might have shifted, if you've got those kinds of records. Otherwise, you want to consider going forward, making sure you're picking up the new opportunities. And you'll want to monitor for the making of regulations that would expand the scope of categories of further processing deemed to be compatible, because that's another of the areas where the Secretary of State is given the power to make regulations. Next, we have automated decision making. Section 80 of the Data Use and Access Act replaces Article 22, brings in new provisions replacing Article 22 of the UK GDPR. So whereas until recently, until last month, data subjects had the right not to be subject to solely automated significant decisions, so decisions producing legal or similarly significant effects, reliant on certain lawful bases. Now there is essentially an authorisation to make automated significant decisions, including based on special category personal data, provided certain conditions are met. And there's also clarity as to what constitutes a solely automated decision. So as well as expanding provisions around the reuse of data, you can do more with the data you've got, and you can use AI and other machine learning tools for automated decision making more. So what happens? Article 22 of the UK GDPR is removed. We now have new articles 22A to D of the UK GDPR. So these provide that there's some decision around what constitutes a decision based on solely automated processing. That is if there is a decision with no meaningful human involvement. And the Secretary of State is going to be allowed to make regulations, none have been made yet, but make regulations around what constitutes meaningful human involvement. In the AI context, there's a lot of debate and dispute at international and national level about, the extent to which having a human in the loop is a requirement of responsible AI, and if it is, quite where that should sit. And a lot of the debate right now is in the context of defence and weaponry and autonomous weaponry. And the UK government has a position on that, which is essentially, I think, is aligned with the US position, seems to be from what's published so far, which is that kind of potentially accountability after the fact might be enough. It might not need a human to review and kind of approve a decision and press a button. It might not need a human supervising decisions being made and being able to intervene. Potentially, is it enough to have something after the fact? So what meaningful human involvement is, what the ICO says about it, what it means, what the Secretary of State says about what it means, it's going to be really important. And we don't have much clarity on that. Nevertheless, I wouldn't kind of wait to take advantage of these changes. I think I would take a more cautious approach in terms of what human in the loop means, depending on the nature of decisions. But these restrictions are applying to, largely in relation to your significant decisions, in which case, having some kind of human intervention in there is going to be needed. So it retains the definition of a significant decision, legal or similarly significant effect. And then it says when you're considering whether there's meaningful human involvement, you must consider the extent to which a decision is reached by means of profiling. You then have the restrictions on automated decision making, or Article 22B. So if it's based entirely or partly on processing. Based on special category personal data, it can't be conducted unless a particular condition applies. Those are where there is explicit consent. It's necessary for entering into or performing a contract, required or authorised by law. Or point G of Article 9.2 applies. There have to be safeguards, so where a significant decision is taken by or on behalf of a controller in relation to a data subject, based entirely or partly on personal data and based solely on automated processing. Note, this doesn't only apply to automated decision making based solely or partly on special category personal data, but you have to have certain safeguards in place. Those safeguards must consist of or include measures to provide the data subject with information about decisions, enable them to make representations, enable human intervention, enable them to contest decisions. And then there are provisions there around Article 22D about the Secretary of State and what regulations he is entitled to make. Here we have a flow chart. You may not be able to see it easily on your screen, but if you can't, it does form part. There's a link to it in the resources section that will come at the end of this webinar, and it's also in the blog post on our website right now, the title of which is, I believe, Autopilot, where we did a deep dive into the automated decision-making changes. So this is the flow chart showing you how you would decide whether you're entitled to do automated decision making under the UK GDPR and Data Protection Act 2018, so pre-Data Use and Access Act, and this version is the post-Data Use and Access Act requirements. As I say, you'll be able to download that, and we'll also be able to make available copies of our slides today. So what does it mean for you? This is a relaxation of the circumstances in which you could do automated processing. So review projects. If you've got records, look at your projects where you've recently said, actually, we're going to reject this. We can't do automated processing here, to think about whether it could now be implemented under the new relaxed restrictions that came into force last month. You'll want to make sure you're implementing mechanisms to comply with necessary safeguards in respect of significant decisions. And you'll want to monitor for the making of regulations amending what constitutes meaningful human involvement, a significant decision, or necessary safeguards, as well as looking out for the ICO's guidance on those things. The next change was in relation to children's higher protection matters. So Section 81 of the Act imposed new obligations on information society services likely to be accessed by children, requiring them to have particular regard to the rights of children in respect of their personal data. That's been achieved by amending Article 25 of the UK GDPR on data protection by design and by default, and introducing new Articles 1A and 1B. How that interacts with the age-appropriate design code and children's code and the requirements in there arguably imposes a higher standard. So that'll be interesting to see whether and when the ICO updates those and how it applies in practice. There's obviously at the moment the ICO has been on something of a run of enforcement action in relation to children and processing of children's personal data. This could give them further ammunition to continue that. So identify whether you fall in the scope of the provision, amend your ROPAs, DPIA templates and technical and organisational measures, which could include privacy notices, consent mechanisms, security measures, etc., to reflect the additional considerations to be given to and recorded in respect of children's higher protection matters. And when you do an additional assessment, make sure you're recording the outcome of that to make sure you can demonstrate you've done so. Next chunk of changes relating to processing for the RAS purposes. So you've got a range of provisions came into force, a new definition of the RAS purposes, revised definition of consent for processing for the RAS purposes, further relaxation of the purpose limitation principle, which we've already addressed in brief, new safeguards for processing for RAS purposes, limitations on the transparency requirements when you're dealing with processing for RAS purposes, which we've already addressed because that came into force earlier. The ICO has said final revised guidance on purpose limitation will be published this summer, so we have to wait for that. So Article 4 of the UK GDPR gets a new Article 4.2. So all the current text of Article 4 of the GDPR has become Article 4.1. There is now Article 4.2. Processing for the purposes of scientific research is processing for the purposes of any research that can reasonably be described as scientific, whether publicly or privately funded, and whether carried out as a commercial or non-commercial activity. That includes processing for technological development or demonstration, fundamental research or applied research, so far as those activities can reasonably be described as scientific. That is not really new. That was already included in the recitals to the UK GDPR, but they are not binding. They're indicative, and so that is now been codified and brought within the scope of Article 4. So again, hopefully to provide more certainty and confidence to relevant entities. There is a change, however, that says processing for the purposes of study in the area of public health that can reasonably be described as scientific. It must be conducted in the public interest in order to benefit from the definition of RAS purposes, from the particular changes and relaxations that apply to RAS purposes. Public health studies must be in the public interest. Any other scientific research, though, doesn't have to be in the public interest. Clarity that historical research can include genealogical research, and then what constitutes processing for statistical purposes. And then you've got an exemption to how consent applies is now in Article 4.6 or 4.2.6, that data consent is to be treated as falling within the definition of consent when you're processing for RAS purposes, even if essentially they haven't had all the information about how data will be used at the outset. Subject to certain conditions around complying with generally recognised ethical standards and an opportunity to consent at the time of collection to only part of research. So if you're collecting personal data for scientific research, you might want to say, give people the opportunity to say, I consent only to this particular processing purpose, or I consent to this and kind of related further future processing in this area. So the purpose limitation principle, further processing, we've highlighted already as we were discussing in the purpose limitation changes, that one of the purposes for processing which is now deemed to be compatible are the RAS purposes as set out at Article 8A.3. You've then got a new Chapter 8A inserted into the UK GDPR. Article 89, which had the safeguards for processing for RAS purposes, has been deleted. That's now been replaced with a new Chapter 8A and Articles 84A to D, establishing the requirements for processing for RAS purposes. So the processing must be the collection of data, and there is then the data is either then being converted into aggregated data, so information which doesn't permit the subject to be identified, or where you've collected data and without this processing you couldn't fulfill your RAS purposes. And then you've got at 84C certain safeguards. These were reflected at Article 89.1 and have now been carried over, relating to technical organisational measures, for example. Processing can't be likely to cause substantial damage or substantial distress, etc. There's also provisions for the Secretary of State to make further regulations in relation to that. And then, as we've already discussed, there are changes at Article 13 and 14 to limit the circumstances in which you're required to let data subjects know about further processing activities. So if you're going to process for the RAS purposes, review your activities to determine whether anything you're already doing could fall within the scope of the definition of scientific research, so you can benefit from these relaxations. There might be things that you didn't previously consider to be within the scope of scientific research that would now count. If so, and you want to rely on that, consider whether you need to revise your privacy notices, ROPAs and DPIAs, and reflect processing activities in your templates, just to ensure that you're identifying and recording ROPAs clearly. Codes of conduct. So Section 83 amended Article 41 of the UK GDPR to reduce the expectation that failure to comply with an approved code of conduct will result in a monitoring body excluding or suspending adherence to the code. So potentially making codes of conduct more attractive. The ICO has published some updated guidance on codes of conduct, and that change is implemented at Article 41.4a. So if you operate a code of conduct, consider whether it provides the permitted breadth of enforcement action. You're not required to get rid of someone now if they don't comply, so you might want to amend that. You could have to consider whether you want to update it, but that will require refreshed authorization. And you'll obviously want to monitor for any changes to existing codes of conduct that you are subscribed to or considering subscribing to. The next big change related to transfers of personal data to third countries and international organisations. So Section 85 and Schedule 7 of the Data Use and Access Act have paved the way for the Secretary of State to make new adequacy regulations in respect of third countries. They've reduced the threshold not only for making such regulations, but also for transferring personal data subject to safeguards by introducing what's called the data protection test, and have thus eased the compliance burden on doing so. Article 44 of the UK GDPR is deleted by way of those provisions. There is a new Article 44A on general principles for transfers. That's largely the same as currently. So you have to meet certain conditions. You either can have adequacy regulations, appropriate safeguards, or a derogation. Article 45, which was transfers on the basis of an adequacy decision, deleted, replaced with Article 45A, which refers to transfers based on approved regulations by the Secretary of State. And the threshold for the making of such regulations is identified here. So what is now in force is what's called the data protection test. What is the data protection test? That's set out at Article 45B of the UK GDPR. It establishes a lower threshold for transfers under the GDPR and under the Pre-Data Use and Access Act. UK GDPR, we were thinking about essential equivalence. You'll be familiar probably with the case of Max Schrems when he challenged the various mechanisms that were put in place to transfer personal data from the UK to the US. And the courts found that they were not essentially equivalent. That is no longer the standard for transfers of personal data from the UK to overseas. The standard is the level of protection for data subjects not materially lower? Not materially lower. That's the standard for the Secretary of State to make the regulations. That's the standard for transfers subject to safeguards. In addition, the criteria to be considered when considering whether protection is not materially lower are narrower than were the case under the GDPR and the UK GDPR Pre-Data Use and Access Act. So you don't have to take into account as many provisions and requirements, particularly relating to kind of what's gone. Let me try and I'm not be able to pull it out from this because you won't be able to see it, but we have got some further deep dive material on this on our website and we'll direct you to it. But that has implications for your transfer risk assessment or transfer impact assessment templates, for your guidance, thinking about whether you can do it. It also has implications for whether you can whether you want to revisit previously rejected transfers. There's also further provision for the Secretary of State to make regulations in relation to safeguards for transfers. There's also some changes in relation to derogations for specific situations, and also provision for the Secretary of State to restrict transfers where there are no regulations in force and the restriction is necessary for important reasons of public interest, which one envisages could be something like in a wartime scenario, there could be an urgent stop on transfers of personal data to certain third countries. If there were to be considered to be a national security risk from transfers to certain countries, that could be implemented then. So you'll want to monitor for new adequacy regulations being made in respect of third countries, which could obviously reduce your compliance burdens, and they will be made against this new lower threshold. You might want to review previously rejected transfers and existing transfer impact assessments to reassess risk in light of revised thresholds. You might want to review and revise your internal guidance, training, templates to ensure that it reflects the new lower threshold, and monitor for the making of regulations establishing new standard contractual clauses, further safeguards, or restrictions on transfers that the Secretary of State is able to make. The Information Commissioner gets new enforcement powers with effect from the 5th of February. Section 98, 99, 100, 101 introduce the power to require a report, make some changes to restrictions on issuing assessment notices, and make provision to make interview notices and change provisions relating to penalty notices. So Section 98 grants the Information Commissioner the power to require an assessment to be undertaken and a report to be prepared by an approved person, effectively enabling the Commissioner to outsource its investigation capacity to third parties. Section 99 removes the current restriction on the Commissioner giving an assessment notice to Ofsted in so far as it relates to information processed for the purposes of in its capacity as registration authority in respect of children's homes, residential family centres, fostering and adoption centres. Quite niche, but there you go. Section 100 granted the Commissioner the power to issue interview notices. So that's to require individuals who either themselves the controller or processor, or who have been employed by them or otherwise concerned in their management or control to attend for a verbal interview, potentially at quite short notice. They can also potentially dictate who their legal representative is by saying they can't be represented by the same legal representatives as the controller. Section 101 of the Data Use and Access Act imposes time limits on the Commissioner taking regulatory action after they've given a notice of intent, so to speed up that enforcement process. So how's this gone about? So you've got an amendment to the existing Section 146 of the Data Protection Act assessment notices. So the Commissioner can currently issue an assessment notice to go and assess themselves compliance by an entity. Now they can require a controller or processor to make arrangements for an approved person to prepare a report relating to those similar things. And then there are provisions for the approval of a person to prepare the report. Essentially, the controller gets first dibs, or other end, it could be a processor here who's being subject to an assessment notice, but you get first dibs to propose someone who should be the approved person. The ICO doesn't like that, then they can appoint someone else. So you'll probably want to think about, who do we know in our network? Who do we don't instruct, so who's not going to be conflicted, but we think is sensible, pragmatic, robust, that we would trust to kind of say, okay, you're going to come in as a kind of independent third party and look at what we're doing. Is there someone you know who could fulfill that role? At Handley Gill, we are willing to act as approved persons for this purpose. So if that's something you're interested in, please get in touch with us. But you'll want to consider, who would you put forward? You might not have much notice to do that. Who would you propose? Then you've got this new interview notice powers. So this is at section 148A, 148B, and onward of the Data Protection Act 2018 introduced. You can be required to go and attend for interview. It's also section 148C creates an offence of making false statements in response to interview notices. And then you've got a change at Schedule 16 of the Data Protection Act 2018, just at paragraph 4, there's a new 4A1 and A2, where a commissioner gives a notice of intent. They must, within 6 months, in any event, as soon as reasonably practicable, either issue a penalty notice or give notice that they're not going to do that. What do those enforcement change powers mean for you? Well, you'll want to consider and identify relevant individuals who could act as the approved person. You'll want to consider and prepare for the financial implications of the potential for an approved person to be conducted to undertake an assessment, because the ICO gets veto over who's notified, but you're going to have to pay as the controller or processor. You're going to pay for the privilege of that approved person doing it, and we've yet to see whether and to what extent the ICO is going to leverage these powers. You're also going to want to prepare for the prospect of directors, officers and staff being required to attend for interview, including the costs associated with legal representation or witness preparation training, given the criminal implications of that. PECR. Lots of changes here too. So Section 70 of the Data Use and Access Act amended Article 6 of the UK GDPR to explicitly recognise that direct marketing is capable of being necessary in the pursuit of legitimate interests. We've referenced that already. That came up down at the new Article 6, 12 of the UK GDPR. In practice, we think it has little practical impact. The ICO's guidance already indicated that, for example, where you're relying on the soft opt-in under PECR, you would be relying on the legitimate interest lawful basis, not on consent for that. So we think this is what people were doing anyway, but nevertheless, it's now codified. For the first time, Section 110 introduces a definition of direct marketing into PECR. So you've got that direct marketing definition there. That came in earlier and we've already talked about that. Section 112 and Schedule 12 amend the rules on storing data on devices impacting cookies and other tracking technologies. This is really important. So Regulation 6 of PECR, gone. You've got a new Regulation 6. And essentially this narrows the circumstances in which you're going to be required to get permission to for cookies. In Schedule 1A, sorry, in Schedule A1 to PECR, these are the circumstances in which you're not going to have to, you're entitled to store information or gain access to information stored without getting consent. So if it's for transmission of a communication over an electronic communications network, and some of these are replicated from the old provisions, some are new, storing or access strictly necessary to provide an information society service, and what is strictly necessary is clarified here. So protecting information provided in connection with the service, ensuring security of equipment, preventing or detecting fraud, preventing or detecting technical faults, enabling authentication or maintaining a record of selections. Those are things now that are considered to be strictly necessary to provide the service, and which you'll have to have a privacy notice for. You have to have a cookie notice in terms of making people aware that it's happening, but you're not going to be required to get consent for. Collecting information for statistical purposes will not require consent. Provisions relating to website appearance won't require consent, and where it relates to emergency assistance, you won't require consent for cookies or tracking technologies. So you should review your cookie notice and cookie banners, determine whether you're entitled to simplify or otherwise redesign and amend these. Review your use of other tracking technologies to ensure it falls within the scope of Regulation 6. So it's important that people have often forgotten about other tracking technologies, but it's absolutely clear that this is about any information storage tracking. And so you need to make sure you're reflecting that and complying with that too. And you want to monitor for the making of regulations, amending the circumstances in which the storage or accessing of data on a device will be accepted from the prohibitions. There could be further changes brought into force by the Secretary of State. Look out for those. Section 114 of the Data Use and Access Act has introduced a version of the so-called soft opt-in, so the carve-out from the obligation to obtain consent to send direct marketing in relation to similar products and services to your existing customers or people who've been involved with you in the course of a sale or negotiations for charities. So a charity version of the soft opt-in by amending Regulation 22 PECR. It's not quite the same, obviously, because this isn't about charities selling products and services. This relates to being able to essentially do fundraising. So charities will be allowed to send or instigate the sending of electronic email marketing, or it's for the sole purpose of furthering the charity's charitable purposes. They got the details of the person in the course of them expressing an interest in the purposes, in the charity's charitable purposes, or offering or providing support to further one or more of those purposes. So offering a donation, providing a donation, offering to volunteer, those kinds of things. And the recipient has been given a simple means of refusing to receive direct marketing at the time they provided the information. As a consequence, charities who want to use the soft opt-in will need to first identify potential recipients. That could be donors, potential donors, volunteers, etc. They should design or revise their data collection mechanisms from relevant potential recipients to offer them the option to opt out of direct marketing, which can then be actioned now this is in force. Review and, if necessary, revise your communications with existing registrants to ascertain whether they can be considered to meet the new requirements, and if they can, add those people to your database. Review and revise or prepare privacy notices, legitimate interest assessments, DPIAs, etc., to reflect your new or expanded processing activity in this regard, and revise your internal guidance and training to reflect the new approach. Section 115 of the Data Use and Access Act 2025 modernises the enforcement of PECR and aligns it more closely with enforcement under the UK GDPR by replacing the current wording of Regulation 31, which provides for an enforcement regime based on an amended version of the Data Protection Act 1998 enforcement regime, with a regime based on an amended version of the 2018 regime. So the significant changes here that you need to be aware of, the maximum penalty is increasing from £500,000 to 17.5 million, or 4% of annual global turnover, whichever is the greater. So you've now got GDPR, UK GDPR enforcement penalties for PECR. Regulator access to a wider enforcement toolbox, expanding on existing powers of entry and inspection to incorporate all the powers under the Data Use and Access Act: information notices, assessment notices, interview notices, enforcement, consequential offences, etc., and expanded directors' liability for offences. As such, you need to brief your board or management about the increased financial exposure associated with unlawful marketing. You need to review your risk assessments related to your marketing activities in light of that. You want to ensure that your staff are trained to recognise and escalate new types of enforcement notice that could be served in the PECR context. You want to ensure that your directors and officers are aware of their expanded liability, and you'll want to consider the insurance implications of these changes. Section 116 imports the GDPR and UK GDPR concept of industry codes of conduct into PECR by requiring the regulator to encourage representative bodies to prepare codes of conduct and submit them for approval. So you've got new regulations 32A and 32B that make and 32C that make provision for that, and at 32C highlights that adherence to a code of conduct approved may be used by a person as a means of demonstrating compliance with these regulations, so cementing the status of codes of conduct as a valid accountability mechanism. So for PECR purposes, consider what opportunities there may be to design codes of conduct to introduce standardisation and compliance assurance, whether that be across specific types of organisations or specific processing activities across a variety of organisations. Establish a working group to design such a code and submit it for approval, and monitor for industry groups seeking to corral support for codes of conduct to consider whether and how you will engage with those processes. You could see opportunities, for example, for the IAB in the context of programmatic advertising, for example, to seek to prepare and have approved a code of conduct. There are then various miscellaneous provisions that brought into force on the 5th of Feb. Relating to processing and reliance on relevant international law, elected representatives responding to requests, manifestly unfounded or excessive requests to the Commissioner, consequential amendments to the EATSET regulations, transfer of property to the Information Commission, and minor provision about data protection. We go through those here. So lawful basis, sections 72, 3 and 7 provide a lawful basis for the processing of personal data in the context of its provision to law enforcement or other public bodies in connection with processing in reliance on relevant international law, which is currently limited to the Cloud Act. So if you receive that request, you can respond to it, and that gives you a lawful basis for doing so. Your processing still has to be fair. Section 73 extends the period during which former MPs may continue to process special category personal data in the context of responding to requests from 4 to 30 days. Section 94 of the Act clarifies the interaction between the Information Commissioner's duty to perform its task free of charge and its entitlement to charge for or reject manifestly unfounded or excessive requests. Section 105 makes consequential amendments, including in relation to the ICO's enforcement powers, to the Electronic Identification and Trust Services for Electronic Transactions Regulations 2016. Section 120 empowers the Secretary of State to implement measures for the transfer of property, rights and liabilities from the Information Commissioner to the Information Commission. And Schedule 11, various paragraphs of that make amendments to the Data Protection Act 2018, pretty much to reflect that references to the prevention or detection of crime should also include the investigation of crime and other minor amendments. The Data Use and Access Act 2025, Commencement No. 6 and Transitional and Saving Provisions Regulations 2025 didn't just make provision for sections of the Data Use and Access Act 2025 to come into effect on the 5th of Feb 2026. It also made provision for certain provisions to come into force on the 19th of June 2026, and those are the controller complaints provisions. In particular, Section 103 and Schedule 10. So Section 103 of the Data Use and Access Act 2025 will create a new right on the part of data subjects to complain to the data controller by amending the UK GDPR and Data Protection Act 2018 and consequential amendments, including for the role of the ICO. The ICO has published draft complaints guidance already. This has been consulted on, but the final guidance has not yet been published. The draft complaints guidance URL is on the screen now. So what's happening? There is a new section 164A of the Data Protection Act introduced relating to complaints by data subjects to controllers. This requires that or provides that a data subject may complain to the controller if the data subject considers there to have been an infringement of the UK GDPR or Part 3 of the 2018 Act as applicable. Controllers will be required to facilitate the making of complaints under this section by taking steps such as providing a complaint form which can be electronically completed and by other means. Receipt of the complaint must be acknowledged within 30 days of receipt, and the controller must take steps to respond to the complaint and inform the complainant of the outcome of the complaint without undue delay, or there is no technical backstop date for compliance with that requirement. And those in taking appropriate steps to respond to the complaint includes making inquiries and informing the complainant about progress on the complaint. There is also then at Section 164B of the Data Protection Act 2018 a new provision which enables the Secretary of State to make regulations to require controllers to notify the Commissioner proactively of the number of complaints they've received. No such regulations have as yet been made, but they could be made. So it's something to keep an eye on. So controllers are going to need to update their privacy notices to reflect that there is a new right of complaint, essentially a new data subject right. There's a right to complain direct to controllers once in force. You're going to need to establish a complaints mechanism and a procedure for handling complaints under the new right to complain once it's launched in June. You're going to need to consider whether you're going to need additional resources to manage the complaints, and bearing in mind that you've also already got potentially shorter periods for complying with data subject access requests if you've been routinely giving yourselves the 2-month extension. You're now going to have complaints to deal with too. You're going to need to consider that, what you need, and get those in place. And you're going to want to monitor for the making of new regulations requiring the collation and reporting of data subject complaint statistics. You're also going to want to bear in mind that the ICO has changed its own approach to the handling of complaints. In practice, it has in fact already been requiring complainants to complain to controllers before it will consider data protection complaints. That's being formalised. And the ICO's approach now is going to be that it will essentially receive complaints and note them. And only if the complaint is obviously kind of particularly high risk, or if there are multiple complaints, kind of particular controllers are accumulating multiple complaints, will the Commissioner therefore take a further look? There is a risk that with the new complaints requirements and the ICO deciding to kind of investigate fewer complaints potentially, at least at the outset, individuals may be more likely to seek to pursue redress through other mechanisms available to them, in particular bringing proceedings in court. There are still some outstanding provisions of the Data Use and Access Act 2025 that haven't yet been brought into force. Largely, they relate to the reform of the Information Commissioner's Office. So the Information Commission has technically been established already by legislation, that by the earlier provisions. But provisions not yet in force are relate to the abolition of the Office of the Information Commissioner and the transfer of functions from the Information Commissioner to the new Information Commission. There's also an amendment that's outstanding in relation to the Victims and Prisoners Act 2024. So there's now an opportunity for some Q&A. If you've managed to stay with us all this time, there is a lot of change that either has happened or is due to happen. If you've got any questions, you should be able to drop the Q&A in now. I've got the Q&A panel open so I can see if you ask any questions. Only if you ask a question in the chat box, just to say only I can see it, everyone else can't see it. It's only if you do it in the chat that other people can see it. We have got a raised hand. Please note this is being recorded, but we have a raised hand and a question. So please do go ahead. You're unmuted my end. If you unmute yourself, you should be able to ask your question. I can't hear you asking your question. If you're unable to unmute, if you want to drop your question into the chat, into either the chat box or the Q&A, I can deal with it that way if you can't unmute yourself. And we'll hold on for a moment while you do that. While we're here, I'm just gonna move us on. On the screen right now, you should be able to see a QR code. If you scan that QR code, that will take you to a page on our website with resources relevant to this session. We will also, after this session, add a link there to the recording of this session and to the slides, so that you can access those. But it's got links to where we've talked about, we've done a deep dive on particular things. That's there. It's got links to all of the blog posts we've done relating to the particular commencement regulations when they've been made and the changes they're bringing into force, as well as our previous webinars on the Data Use and Access Act implementation and passage. So at the moment, we don't seem to have any questions from the audience. If you want to get in touch with us, please do so. We are on X, we are on Blue Sky, we're on Threads, we're on LinkedIn. You can register for our first-hand email newsletter, which is where we advertise our events and webinars first. We always give our subscribers the first chance to register. We generally send our first-hand email newsletter only monthly, apart from last month when we got tricked and decided we took a view that the commencement regulations weren't going to be issued and sent out our newsletter, and then within about an hour of doing so, the regulations came out, so we had to send an urgent update. But generally, our first-hand email newsletter comes out monthly and includes links to all of our blog posts that month that are relevant. You can access our information at www.handleygill.com, and if you have a question, you can contact us at info@handleygill.com, and we'll pick that up and we'll be able to respond. We're happy to respond to any questions you may have there. So this was the Data Use and Access Act 2025, Implementation, Obligations and Exploitation. Hopefully you've come away understanding what has been brought into force, what is yet to be brought into force, what new obligations you have, and what opportunities there now are for you to go away and consider how you can exploit the personal data you already have better, and whether there are opportunities to collect more personal data in your organisation. Again, my name is Nicola Kane. I'm the CEO and Principal Consultant at Handley Gill Limited, an award-winning legal and regulatory compliance consultancy. Thank you very much for joining us today. We appreciate your time. We hope you found it valuable, and we look forward to seeing you at a future session.